In this video, we're going to examine once again the closing statement of prosecuting barrister Nick Johnson in the Lucy Letby case. In this instance, we're going to look at what he said with regard to child M. M for Mike, not N for November. This is a continuation of this series. This is our fifth video looking at the closing statement of Nick Johnson. And by the end of this video, we'll only be approximately 20%, I think not even 20%, through the closing statement. So before we look at what Johnson had to say, I just want to go over a couple of details first. The first thing is that this infant shouldn't be in the court case. This infant did have some problems. This infant did collapse at some point, and I don't wish to trivialise that because I'm sure it can be alarming for the family. But this infant survived, this infant recovered, this infant was discharged. This infant, as far as we know, is perfectly well and will grow into a healthy adult. On its own, again, I've recently discussed the child K case, but on its own, there is no way this is going to be in a court case. It's an absolute joke that this is in a court case at all. But certainly as a standalone case, there's absolutely no chance this is going to be in a court case. That's the first thing to say. The second thing is that Child M is this fairly remarkable case in which Dr. Evans just drops in the idea that Lucy Letby has given the child a noxious substance. Now, we know he said this because it's still on the BBC website, it's still a headline on the BBC website. This is despite the fact that he doesn't claim that this actually happened. This wasn't his so-called diagnosis for this infant. He ruled out noxious substances, but he still managed to say in court that the infant might have been given a noxious substance, even though that's not the allegation. That's nothing to do with what is in the indictment. So I'm not sure how that should be viewed. All I will say is that Dr. Evans would have some serious explaining to do with regard to why he stated that there was a noxious substance potentially involved in this to such an extent that it's a headline on the BBC when he knew damn well that there wasn't. So I've actually skipped over some discussion of child L. The reason for that is that I've already discussed the previous insulin case in my last video on this topic and I don't want to go over it again. That goes on for quite some time, with Johnson trying to tie together various cases even though they're not related at all. So you'll kind of see that at the end of this section, but I didn't want to look at all that because it goes on forever, and it's all complete nonsense. What I will say about this section as a whole is that Johnson is in prime shit-slinging mode for this particular section, and that's what he really is. We give these kind of very high-handed names to prosecutors and barristers and so forth, but essentially he's just an extremely well-paid shit-slinger. And that's what he does throughout the court case. He just says a load of random things, one after the other, many of which have absolutely no merit whatsoever, and just hopes that some of them stick. And I didn't know that that's what happened in court when I began this process. This journey, you might describe it as 3 years ago. I didn't know much about the court system, if anything, really. And I had no idea that this was a standard technique and strategy that is used by prosecutors to just say, oh, well, this is the case. Oh, well, you don't like that. Well, this is the case. Oh, you don't like that. Well, this is the case. Okay, we'll try this, we'll try that, we'll try the other, and just hope that something will stick. You actually see Dr. Evans himself do that all the time. You see my recent conversation with him, and he just makes a string of arguments that have no merit, and then I just, very calmly point out that they're all rubbish, and then he just drops them. But if he'd have carried on talking to me, then would have brought up a load more arguments, and I would have dismissed all of those very easily. Then he would have brought up some more. And you're going so far away from the point where, hold on a second, Dr. Evans, what about argument 1? A few days ago, you said that you believed that, you've now dropped it completely. That's why I said to him in my email, seeing as you haven't responded to the vast majority of my points, I'll assume for the sake of argument you think I'm correct, which of course I am. And then he got a bit piqued about that, so I was able to put him in his place. But that's what these people are like. They just sit there saying things, and that's why he said the noxious substance. So you just thought, I'll just throw that in as well. I'll just throw this and I'll just throw that in. That's what they do. That's what the prosecutors do. And he barely sees himself as a medic at this point. That's why, again, you've seen in the conversation that I had with Dr. Evans, he starts saying, have his opinion. He's always constantly emphasising the court. Oh, I said this under oath. Has Shu Lee given evidence in court before? You know, other questions about the court. He barely sees himself as someone who has to make medical or scientific statements that must be tested in the arena of scientific credibility. It's just like, I stand there in court, and if the court says I win, then that means I'm right. And that, of course, is very much the attitude of Mr. Johnson, and that's what we will see unfold in this video. Yeah, and I think I should finally mention as well with regard to Evans, that's why he says so many ridiculous things in the media, because he's used to this thing of I just stand there saying things and just say them over and over and over again, different things, and they can be completely unrelated. Many of my arguments can be disproved, but ultimately it's all about getting the result. And that's why he'll just say things and then he'll completely contradict them later on. Because that doesn't matter in a court case, because the jury just comes up with a verdict, or the court comes up with a verdict in whatever way that is been designated to occur. And that's the end of it. And it doesn't matter that 99% of the arguments you made are complete rubbish. All that matters is the verdict. You never even asked the jury, what did you think about those 99% of rubbish arguments? They don't even often know if they're rubbish or not. So that's why you see him, he'll say that there'll be some film that comes out and he'll say something about that, and you think, well, he just completely contradicted what he said previously. And I think that's partly naivety about the way the internet works, but it's also partly this mindset that they have, that Johnson absolutely shares as well, of I will just stand there saying things over and over again. They may have no credibility, they may have no evidential basis, but I'll just say them, then I'll move on to the next thing, then I'll move on to the next thing, and I'll pile up as many arguments as I possibly can. And as I say, I describe it as shit-slinging. Hopefully some of it will stick to the wall, and then the jury will convict, and then I'll say, hey, I did a great job. Evidentially and intellectually, it can, and certainly scientifically and medically, it can have absolutely no value whatsoever, but that is just the technique that they use. So I'm hoping that there won't be too much analysis of this transcript, because a lot of what Johnson says is complete rubbish. But it begins with him talking about the paper towel. So you may have seen my video previously about this paper towel that was found in the bag, in the Morrison's carrier bag under Lucy Letby's bed. And although Johnson doesn't use the term trophies in this section of the court case, he uses the term collection, as if these things have been collected, as if they've been treasured. So I think this notion that they are trophies, although that was a kind of insinuation that was made, I think, largely by the media, the germ of the idea is definitely contained within this section of the transcript and within other sections as well. I'm not going to read this opening paragraph. I just wanted to show that as a precursor because it's referenced here as we continue. The paper towel thing, I mean, the idea that someone's going to keep a paper towel as a memento is so ridiculous, and I've analysed that already in great depth. But Johnson talks here about the paper towel coming home with Lucy Letby, and he kind of makes this facetious remark about, sounds like a dog following on behind, doesn't it? Following on a leash would be a better way of putting it, of course. These are inanimate objects, and the explanation, I collect paper, how long has Lucy Letby had to come up with a reason? So what he's trying to do here is he's trying to frame Lucy Letby's explanation as being weak. Of course, what is actually weak is the piece of evidence itself. It has no evidential value at all. Lucy Letby doesn't have to come up with an explanation for this because it's obviously complete rubbish. But so he goes on, here we are now 7 years later. The best reason is I collect paper, but I didn't know it was there. So she didn't really say that at all. She said she didn't know how it came home, but it will have ended up in her pocket accidentally, like the handover sheets. But I don't want to dwell on this too much, but again, these were kept in a bundled up Morrison's carrier bag under her bed. They clearly were not treasured in any way. Obviously, the prosecution, as it's a physical item a so-called exhibit in the court case. They have to try and make a lot out of it, but really it's just complete rubbish. And then how do these ideas go together? Avid collectors are usually sad old men like me. Most collectors know what they've got in their collection, don't they? Yeah, because it's not a collection, obviously. It's you that's saying it's a collection, not Lucy Letby. Lucy's saying these pieces of paper mean nothing to me. That's obviously true. It's obviously true that they mean nothing to her. That's why they're in a bin bag in a garage and bundled up in a paper. It's not like she's looking at them in any way. That's why in the Netflix documentary they emphasise this supposed keep box, but actually virtually none of the handover sheets are in there. That's why. That's when they make the claim, oh, they're chronological. Not that it matters if they're chronological. It's meaningless if they are chronological, but of course, they're not chronological. We know they're not chronological because there are only 5 in the box. But they very strongly implied that all of the sheets were in the keep box, which we know isn't the case. In fact, 2% of the sheets, less than 2%, are in the keep box. And so, by definition, they can't be chronological. Anyway, let's continue. It's nonsense, isn't it, ladies and gentlemen? Absolute nonsense. So, again, this is a very typical thing they do. Evans does this as well, where they project what they are actually doing onto someone else. So, it's Johnson who is talking absolute nonsense, so that's why he's projecting this onto Lucy Letby instead. Nurse B told us that she was in nursery 1 in the middle of the nursery facing baby M's incubator talking to Lucy Letby when things happened. She couldn't remember Mary Griffith being there, but she did remember Mary Griffith being there slightly later. So this is related still to the paper towel. It's just simply completely unproven. There's not even any evidence to suggest that Lucy Letby fished this out of the bin as is supposedly required. I mean, Mary Griffith couldn't say definitively, obviously, that she put this in the bin because it's some nondescript event that she can't possibly remember. She said, I would have put it in the bin. So we don't know that it ever went in the bin. Obviously, overwhelmingly likely, 99.99% likelihood, it never went in the bin at all. Dr. Jairam told us that there was an issue with blood perfusing the lungs to pick up the oxygen. Do you remember the gas exchange diagrams that Professor Kinsey explained to us as to how the mechanics of it all works? And it is a signature, isn't it, of the consequences of many of these attacks. And Dr. Jairam arrived. Baby M was receiving CPR, led by Dr. Yuko. So what we're going to see suggested here by Johnson is that there is the same signature with this infant as there are with others in the court case. Now, I don't know whether he realises that he's talking complete rubbish. He possibly doesn't, because his expert is Dr. Evans, and Dr. Evans has told him, oh, these rashes and discoloration are really significant and they indicate the same air embolisms, injection of air across the whole court case. He may not know that what he's saying is absolutely medically, scientifically, evidentially unsupported. He may believe that it's reasonable. You know, we can assume sometimes that because Nick Johnson is prosecuting and because he has said things that are complete rubbish, that he knows that everything he's saying is complete rubbish, and he will know that some of it is very poorly founded, and he will know that some of it is rubbish. But he may genuinely believe that the signatures that Dr. Evans has told him are universal across these cases is correct, and he may also think that these infants have indeed collapsed for no reason, as Dr. Evans has told him. It's just that we know now that these infants have very different clinical signs, but that's just never been, potentially that's never been communicated to Johnson, so he may not actually know this. The protocol was well underway. He had pulseless electrical activity. In other words, the monitor was detecting some electrical activity in the heart, but the medics couldn't feel a pulse at the very edge of life. And the overall resuscitation took 30 minutes with no spontaneous response. The longer a resuscitation goes on, the less likely it is to have a good outcome. So I'm not going to respond to any of that. I should mention as well that the comments related to Professor Kinsey are basically completely irrelevant. And 20 minutes is the usual watershed according to Dr. Jairam. He said it was unusual to get a positive response after the amount of downtime baby M had had. And Dr. Jairam had what he termed as the difficult conversation with the parents of baby L and M, and baby M suddenly recovered, a miraculous recovery. So I should just say that they're going to go on to discuss this further, but Johnson is treating this as if it's suspicious. Of course, a sudden recovery is not necessarily suspicious. is just something that can occur. It's notable that Johnson has mentioned the parents of baby L and M because he continually tries to link this together when they're related, when of course they're completely unrelated, as one is supposed to be an air embolism and one is supposed to be insulin. CPR was stopped. Do you remember what Dr. Jairam said? You might have forgotten. I wasn't sure what we'd done to suddenly make him better. He couldn't explain what had caused the collapse and why baby M suddenly got better. So this is just yet another example of people on the unit not understanding what had occurred. That doesn't mean anything. The fact that Dr. Jairam didn't know why the infant had recovered and why the infant had collapsed, that's not suspicious. That just basically says Dr. Jairam is incompetent. That shouldn't be something that counts in favour of the prosecution. And you'll remember Dr. Gibbs' evidence, won't you, about that inexplicable partial and temporary recovery of baby C. So again here, just trying to link together incidents from unrelated infants, complete rubbish again. This is obviously an example of shit-slinging. We will come to baby C in due course. During the resuscitation, Dr. Jairam noticed skin discoloration. Baby M was generally pale. There were patches and blotches of very bright pink, or certainly more obviously pink, on his torso that flitted around, appearing and disappearing. Dr. Jairam said this direct quotation, because baby M was darker skinned, it was more obvious. He was generally pale, which one would expect in a cardiorespiratory arrest. There were patches of very bright pink, or certainly more obviously pink, because it was on a darker skin background on his torso that flitted around. These sort of pink patches, for want of a description, better patches. They would appear and disappear, then other ones would appear and disappear. I noticed them on his abdomen because that's the most obvious bit of his body that you could see, because the rest of his body had people covering his chest doing CPR. I noted them sort of when I got there during the start of the resuscitation. I can't comment on how long they continued to be there. Once circulation was restored and his heart rate came above 100, they vanished. I had never seen this before baby A. When she was asked about... So I'll stop there actually. So we'll come back to that in a second, but this is the kind of key item of evidence in the case, the supposed discoloration. So what Dr. Jairam has done, and what the prosecution has done in the court case, is misinterpret general skin discoloration and localized skin discoloration that is broadly associated with circulatory collapse. And what Dr. Evans has then done is completely misuse Professor Shuli's paper in support of his theory, which is completely incorrect. And then what the prosecution has done is create a unified theory across all of these infants when they have different types of discoloration, all of which are localized or generalized, but they are presented as being the same when they're not the same. Even if they were the same, they still wouldn't be indicative of air embolism because they're not the right type of discoloration. But I'm just going to show this, demonstrate this to you briefly. So, if there is an air embolism, the only form of discoloration associated with this will be a pattern of red blood vessels spreading out from central to peripheral areas resembling a tree. Generalized skin discoloration essentially means that a large area of the body is discolored in a uniform way. And an example of localized skin discoloration is when you fall and hurt your knee. There can be a patch of localized skin discoloration, typically blue, purple, red, or brown. These are the three types of skin discoloration. They are all distinct, they are all different, and the form of discoloration associated with air embolism is very explicit and very distinctive, and it simply does not occur in this case. None of the infants in this court case exhibit the patterning described in 1. The discoloration and rashes described are also not universal. This is something that Ben Myers pointed out in his application to have them thrown out the court case that was rejected by Judge James Goss. I've been over that in a previous video. What you see is numerous skin discolorations that are associated with generalized and localized symptoms that are indicative of circulatory collapse are all being put under the umbrella of air embolism when none of them are actually indicative of this actual condition. So there are physical reasons that embolism manifests itself in this very specific way. I won't go into that in this video, but they explain why only the patterning described in 1 is indicative of an air embolism. No one disputes this. Indeed, it cannot be disputed. It's impossible to dispute because the physical signs are well understood. They've been explained. They've been explained for quite a long time. And the person that's explained them, Professor Hugh Lee, who's obviously kind of centrally involved in the defence now, he is the person who identified this sign in 1980, and that's why it's named after him. I've seen some comments about, obviously very juvenile comments about, it's conceited to name the sign after yourself, but that it's not that he did research and then decided to name it after himself, like Reading, the guy used to own Reading Football Club, called the stadium the Medeski Stadium and named after himself. That's not what happened. He was the first person to identify this, and so, as is procedurally usual, the sign became named after him because he was the first person to ever notice that it exists. Like similar examples like Higgs boson. I don't think anyone accuses Higgs boson of being arrogant, or there's the Crick thing as well in DNA. Crick's the first person to identify that, thus it's named after him. That's why there is the Lee sign, because Professor Lee was the first person to identify it. And then finally is this point that it would be surprising if every single infant that supposedly suffered with an air embolism exhibited discoloration, as the symptom of discoloration is not seen in all cases, far from it. Discoloration is only seen in around 10% of air embolism cases, where in this court case we are expected to believe there are at least 20 instances of air being injected, and they all produce discoloration instead of the 2 out of 20 that would be expected by the law of averages. So just some very rough mathematics here is that if you assume each alleged air embolism event is independent, and visible discoloration would typically occur in 10% of cases, then the probability of seeing discoloration in all 20 out of 20 cases is 0.1 to the power of 20, which equals 0.000000000000000000001, or 1 times 10 to the minus 20. There's approximately 1 in 100,000,000,000,000,000,000,000,000,000,000,000,000, or 1 in 100 quintillion. That's a big number, even for Sir Roy Meadow. So this case that shouldn't ever be in a court in the first place can now just be completely thrown out on the basis of what we've just heard. Incredibly, Lucy Letby serving a full life order for this infant. It is extraordinary. It's incredible, it's astonishing, it's embarrassing. But I'll just continue with the comments of Mr. Johnson. When she was asked about it in an interview, Lucy Letby said this, and you'll remember, I asked her about it in cross-examination as well. Not going to ask you to find the reference now, but if you want to make a note, it's page 5 of the Baby M interviews. She suggested that the lighting in Nursery 1 wasn't very good in that corner spot, and perhaps that was the reason why she didn't spot what Dr. J. Ram did spot. So I suppose you could say there's even a doubt that Dr. J. Ram may have even seen this, considering what an unreliable witness he is, but we can assume for the sake of argument he did see discoloration. That's possible if there's a circulatory collapse. He may be mistaken. We don't really know. There's no way of knowing. This whole part of the description and discussion is essentially obsolete anyway, but I'll continue. Well, I've got 2 words for you to bear in mind when you're thinking of that as an explanation, ladies and gentlemen. Baby I. You remember what happened to Baby I in Nursery 2 on the 13th of October, and the fact that Lucy Letby claimed to be able to see in very poor lighting when it suited her. And we will get to Baby I in due course. So this is just a typical strategy of trying to make out the defendant is an unreliable witness, and that Dr. Jerram, of course, is very reliable. Dr. Jerram made the point that Baby M's collapse was not typical of any normal infective process. It was similar to what he had seen with Baby A, both in terms of the discoloration and in terms of how he collapsed. So this is just misinterpretation from Dr. Jerram. I mean, Dr. Jerram is just plainly wrong, basically. The lack of there being a reason. He explained that at the time he was operating within certain rules of engagement. You'll remember the cross-examination, I'm sure. He had never seen this before these cases. Do you remember he was asked in answer to a question? So again, this is something that is emphasised, oh, we'd never seen this before. But you didn't understand what was happening. That's really the problem. I mean, on this neonatal unit, they don't seem to have seen anything before, whereas in fact, if they were more experienced, and if they'd worked on a level 3 unit, and if they had neonatologists on the unit, you would find that a lot of the things that they considered to be extraordinary were actually nothing out of the ordinary at all. They just misinterpreted them, or couldn't understand them, or had never seen them before. But that doesn't mean they're suspicious, or there's anything unusual about them. It just means they didn't know what they were and they'd never seen them before, due to what is basically incompetence in many cases. So then we go on. He asked a question. His question was this: are you suggesting that I didn't see it and then perhaps confabulating it? That's doctor or lawyer speak for making it up. Well, what is Lucy Letby's case on whether or not Dr. Jerram is making things up? I mean, essentially it doesn't matter because the discoloration is irrelevant to the allegations. It can't be used evidentially to support the allegations, so it is therefore completely irrelevant. Unfortunately, because Lucy Letby was convicted of this case, you can see the quality and calibre of evidence that the jury received, and you can see the quality and calibre of this court case. Had it been a fair process, had Lucy Letby had the experts in a defence who exist now, very obviously there would be a different result. Even if you don't think there'd be a different result on every case, which I think is clear that there would, there's no way she would have been convicted on this case. That there's no evidence. The one item of evidence is that Dr. Jerram in the dark saw a rash and Dr. Evans misinterpreted it. And we know that it's complete and utter rubbish. Yet Lucy Letby is still sitting there in prison. And if she was found not guilty on every other case, but found guilty on this one, she'd still be facing life in prison on the basis of this complete crap. So he says, you'll be the judges of that. Then he moves on. It was said that if this was what came back to Dr. J on behalf of Lucy Letby, quote, if you'd seen a rash that looks the way you've described it to us on baby M, you would have recorded it. That's absolutely true. Of course you would have recorded it if it was significant, but then we know with Dr. J-Ram, he didn't manage to mention the supposed attempted murder of a baby by Lucy Letby in the case of Child K for well over a year, over 400 days. So it's not that surprising that he didn't record the rash and he didn't write it down. Of course you would write it down. And so it says here, in other words, because he didn't write it down, he must have made it up. I don't think that's necessarily the point. The point is, how can it be deemed reliable if he didn't even record it at the time? Indeed, the prosecution tries to hold this against Lucy Letby all of the way through the court case, even though Lucy Letby is the most diligent, the most conscientious person on this unit, the person who fills out the most datex, the person who tries to raise standards on the unit. That is why she's in the dock. That's why she's been convicted. Because she's around the most, she raises the alarms the most, she points out the mistakes on the unit, whereas everyone else is happy to just shrug their shoulders and say, oh, well, never mind, we did the best that we could and we just never seen anything like this before, and the only possible explanation is that Lucy Letby's done all of this. And look, we think we saw some rashes. We never wrote it down at the time, obviously, but, these rashes are probably all the same, and they're probably the explanation is that they're embolism, so we'll stand up in court and say that. Like, it's an absolute joke. And I hope you appreciate my efforts not to swear in these videos. I've done over 200 now, and I've never properly sworn once, and I've never had to re-record anything because I swore. And that's taken quite a lot of discipline and self-control. So I hope you appreciate that. Another time he was accused of seeking to create dramatic detail by using the phrase physical chill by describing how he felt when he later found a paper on embolism. Well, ladies and gentlemen, we suggest that not only is Lucy Letby prepared to kill babies or try to kill them, she's also prepared publicly to trash the reputations of responsible professional people in an effort to get away with it. So there's several things to say about this. Firstly, this is another projection because Nick Johnson is trashing Lucy Letby, who's a professional person. Secondly, the physical chill that Lucy Letby, that J-Ram felt, is just him misinterpreting what he said that he never wrote down. And then the third thing is, it's not Lucy Letby that is saying this, it's her defence. She didn't make these accusations. These were things that were said in cross-examination. As he was being resuscitated, baby M's blood gas was measured at 1622 by Nurse B. This is all irrelevant. She used the machine, she took the printout, she entered the data on the sheet and threw away the printout in the secure rubbish. And that printout was found under Lucy Letby's bed. Irrelevant. Nonsense. We've been over this countless times. It's complete rubbish. Quote, I collect paper. What a bit of paper to add to your collection. Well, it's not of any... What you're saying, she treasured the blood gases. Is that what you're saying? What are you saying, Nick? So, ladies and gentlemen, you can see immediately the parallels, can't you? So this is the bullshit he does of, oh yeah, all the cases are the same. Let me show you the relationships between them again. Let me throw some more shit around. That's what I do after all. That's what I get paid to do. I get paid thousands of pounds a day to do this, believe it or not. With what happened to the baby's E and F twins, is it an innocent coincidence? Or when you factor in the baby L and F were being deliberately poisoned, does it point to the fact that first, someone was sabotaging all four? No, it doesn't. And secondly, that Lucy Letby was the saboteur. Again, no, it doesn't. Yet another collapse just after the family had left. So, I mean, this is just very obviously a coincidence. Even if it's true, it's debatable whether or not it's true. But even if it is true, of course, it's just a coincidence. Anyone could come in out any time. Anyone could collapse any time. And of course, you're only alleging this in relation to a few infants. So it didn't happen for most infants in the case. The vast majority of collapses. So you're talking about a small number of things. So you can't cite any meaningful pattern there. It is obviously just a coincidence. So anyway, it goes on. Yet another collapse just after the family had left, just after the interested observers had left, just when Lucy Letby was unsupervised and got the opportunity. What are the chances of that pattern of collapses happening time and time again? Well, it didn't happen time and time again. It didn't even happen in 25% of the collapses in the court case. It happened in a very small minority of cases, and the chances of that happening are impossible to calculate, but it can very easily be a coincidence, Nick. So another thing to mention here after he says just when people have left the room or are being distracted, notice that you didn't cite all the cases in which we know there were people in the room, we know there were loads of people around. Even if people have just left the room, it's still risky to do any of this stuff, but given that we know for a fact that there are numerous allegations and numerous alleged acts, at times when there were definitely other people in the room, there were definitely loads of people around, sometimes Lucy Letby can't even be positioned near the infant. So, making this all out to be some undeniable circumstance that points to the guilt of Lucy Letby is, again, complete rubbish. But everything that is said in this section in relation to the collapse of Child M, who didn't even die, who's now perfectly well, it's all complete rubbish. So after the collapse of Child M, we move into the night shift of 9th into the 10th. Dr. A told us about his involvement at 21:35 that evening. Baby M's collapse had been about 4 p.m, about 1600 hours, so about 5 hours later or so. So we have this dreadful collapse, 6 doses of adrenaline, 30 minutes of downtime, and inexplicable recovery. And by 21:35, there was a plan to take out Baby M's endotracheal tube, evidence for truly astonishing recovery. Yeah? And? What does that mean? So the infant recovered when they weren't expecting it. There was a lot of things that happened on this unit that they weren't expecting and that they didn't observe and that they didn't understand. So how astonishing was this recovery, really? They say it was astonishing. Was it actually astonishing? And even if it was astonishing, what the hell does that mean anyway? It doesn't mean anything. Every bit as astonishing, we suggest, as the collapse. At midnight, the morphine was stopped following a good gas, and Baby M had been settled all evening. The tube was taken out. He was put onto BiPAP within 12 hours of this brink-of-death collapse. Samantha O'Brien and Laura Eagles, respectively, were the nurses who looked after Baby M on the night shift and the following day shift. And by the time they were involved, there was no cause for concern for this child who'd had such a devastating collapse. I'm not really sure why you're telling us this. It's completely irrelevant. On the day shift of the 10th, Dr. Gibbs examined Baby M, and although at the time he queried necrotizing enterocolitis and sepsis, he said that they could be excluded by the subsequent investigations, and by that day shift the only problem Baby M had was a slowing in his rate of breathing, which required a dose of caffeine. What you did hear, however, from Professor Stivaros was that Baby M had suffered a brain injury when he was sabotaged by Lucy Letby. So all of that is basically irrelevant, but I just want to look at what Professor Stivaros said, because that's very important. So Professor Stivaros said the following: the imaging can only describe the brain damage resultant from this episode. It cannot determine the underlying cause of the collapse, about which I defer to clinical opinion. So Stivaros played an incredibly minimal role in the court case. He didn't appear as a witness, he just made a few statements. None of them were in any way supportive of the prosecution. Mentioning him here is basically meaningless. I just want to mention as well, because that sounds quite serious, but I just want to be clear that Child M suffered no after effects from this collapse. child M was a healthy infant when discharged. So the tragedy of this is that the parents of child M currently believe that Lucy Letby has damaged their infant with an air embolism based on symptoms that are completely wrong, and they have a healthy baby and a healthy child, and they're probably very grateful for that, and that's a good thing, obviously. But they now have this belief system that's been put into their brain by an incompetent investigation, by the shall we be generous and say bizarre interpretations of Dr. Evans, and by the crap that's in this court case. So I want you to note something here. Johnson then says, of course, Professor Stivaros didn't say when he was sabotaged by Lucy Letby. That's the bit I have added. So that might seem pretty despicable that he said that, trying to associate the two, but he has at least corrected himself here. However, I put it to you that if he hadn't corrected this, the judge would have done absolutely nothing. There's no indication the judge was going to do anything. So I don't even know why he bothered saying this. He might as well just have continued with his statement that Professor Stivaros stated baby M had suffered a brain injury when he was sabotaged by Lucy Letby and just left that in the case. Because I'm pretty certain at this point that Goss would not have said, well, actually, that's not accurate. As a result of this incident, baby M suffered a brain injury. It's perhaps no wonder if he'd suffered a brain injury that he wasn't in absolute tip-top condition. Over the next 24 hours, he'd had a very close brush with death. In the days that followed, he no longer needed any stimulation for his breathing. While we had expert evidence from both Doctors Evans and Bohin, of course we used the term expert loosely, they both told you that before his collapse at 1600 hours, baby M was breathing unassisted in air. He'd been taken off enteral feeds because of the bile-stained aspirates I told you about. The blood test and the observation chart provide no evidence to suggest that he had any form of infection. His collapse was as precipitous and dramatic as those of many of the other children, as was his recovery, so they're just trying to tie this together again. And at the risk of boring you, I remind you that this is a fairly typical picture in these cases. Yeah, I don't think anyone could have missed the fact that you're trying to imply that. As Dr. Evans said, the small bile-stained aspirate of 1430 was not a marker of impending collapse. Dr. Bohin added that babies of this gestation being taken off feeds is a very common occurrence, and subsequent investigations revealed there was no gastrointestinal issue. Dr. Bohin also said that the recovery was as perplexing as the collapse. The recovery tells you that it wasn't an infection-related collapse. It was suggested that the lack of blood gases in the hours before baby M's collapse might be meant to have had an infection. So this was a child presenting no signs of concern at all. Therefore, they were not taking blood out of his heel, and therefore it was being suggested on behalf of Lucy Letby that means you can't exclude infection. So I'm not going to respond to any of this. I'm just going to read something at the end. I'll just go through these final comments, because essentially we know the mechanism that was alleged is completely wrong, and we know all the arguments that are made evidentially by the prosecution are either worthless or wrong. So I'll just read out this last bit. Well, Dr. Evans says that's simply not true. He was self-ventilating in air and there were no significant concerns, no reason to do a blood gas. And we know the subsequent tests exclude infection. Both Dr. Evans and Dr. Bohin told us that in their view this was a case of air embolus. So I have to tell you, again, Dr. Evans never looked for infection in any of these cases. Both explained how it could be that you wouldn't necessarily need to be literally at the side of the child at the moment he or she collapses to have been responsible for injecting the air. And this is part, we say, of the evolving means of attack by Lucy Letby. She'd start with baby A literally standing over him and injecting him. This is just complete rubbish as he collapsed. And then she modified her behaviour. You will remember that on the 23rd of February, Dr. Evans was asked where the air goes, as if being able to answer or not answer that question necessarily determines the issue of whether or not this was an air embolus, and you were treated to a very, very long answer. This was an issue taken up with Professor Arthurs on March the 16th. An implication being made by the question was that because there was no evidence of air in the x-rays, then that couldn't be the cause. An air embolus couldn't be the cause of the collapse. So what we should say is that actually, even if air was present, that doesn't mean that it's an air embolus, because we know that there has to be almost immediate evidence of air. Otherwise, you can't cite the air as being evidential of an air embolus, because it can accumulate due to other reasons. Professor Arthurs disagreed with that. He referred to tiles 192 and 238 in the baby M sequence. And unlike the images in the cases of baby A, D and O, I should just say Professor Arthurs is wrong. You'll remember all showed those air bubbles in the prone child overlying the spine and the great vessels. He made the point that because the images of baby M were taken in life, and because the blood is circulating so quickly, with an active circulation in a living child, you would not expect to be able to see air on an X-ray. So, I mean, again, that's misleading, essentially. In answer to a question asked by His Lordship, Professor Arthur said this: most of the illustrations we have of air embolus in newborn babies in the literature are of those babies who have died of a massive air embolus. If it happens that you have the X-ray sufficiently close to when the incident occurred, it's possible you could see that. So the main take-home message, I think, from the X-ray is that if you don't see air, it doesn't mean there wasn't an air embolus. But equally, Nick, if you do see air, it doesn't mean that there is an air embolus, because it's not diagnostic of there being an air embolism. These are not things we come across very commonly in paediatric radiology. So I'm not going to respond to all of that because I've gone into this in great depth in my book. It takes a lot of explanation, and essentially the diagnostic signs of this infant are completely incorrect, and these assertions are basically meaningless. I'm going to go over some details in a second, but firstly, there's this final paragraph here. I'm not going to read it out, but this is how he was trying to, as I mentioned earlier, just try to tie everything together and say, look, it's all the same pattern, ladies and gentlemen, except when it isn't, but I'll downplay that. So, child M in the real world had signs of possible sepsis from birth, including jaundice, requiring phototherapy and hyperglycemia, and was treated with antibiotics. The next day he clinically deteriorated for 4 hours prior to collapse, with abdominal distension, increased work of breathing, raised temperature and bile-stained nasogastral aspirates, which were of concern to the nurse and registrar. The acute episode of desaturation and bradycardia was likely triggered by apnea from sepsis, abdominal distension with ileus, and prematurity. It could also be due to the cardiac eustachian valve, which can cause episodes of desaturation and bradycardia due to intermittent right to left shunting of blood through the foramen ovale. The resuscitation was chaotic, with 2 doses of adrenaline given before the airway was secured. Air embolism is sudden and catastrophic. Indeed, this was cited by Ben Myers in court. It's just unfortunately had no experts to back this up. This is very, very obviously not an air embolism. Let's just continue. And does not present over 4 hours with gradual deterioration. I mean, this just could never in a million years be an air embolism. And the infant would not recover quickly. Patchy skin discolorations are caused by dilation and contraction of small blood vessels in the skin in response to hypoxia, which can occur in many conditions and are not diagnostic of air embolism. Non-specific localized patchy skin discolorations have not been reported in infants with venous air embolism, including intravenous air injection, and only Lee's sign and Liebermeister sign are diagnostic of air embolism. Of course, I explained that earlier in the video. If air was deliberately infused through a central venous line to cause air embolism, the line will have to be reinfused with fluid to prevent detection. Collapse from air embolism occurs instantaneously. It is doubtful this can be achieved quickly enough before other staff in the unit respond to the collapse. So it's concluded by the panel experts who worked on this case that desaturation and bradycardia was caused by apnea from sepsis or the eustachian valve, and the resuscitation was of suboptimal, as indeed were many resuscitations in this court case. And bear in mind, this was produced by 2 absolutely world-class experts at the pinnacle of neonatology working in silos, and they all agreed with each other despite the fact they were siloed. If we compare the two, if we look at the kind of forensic detail to Dr. Evans and Dr. Bowen, the baby was fine and collapsed for no reason. It must be an air embolism like all the other cases. Look at this generalized skin discoloration that is very obviously a typical sign of circulatory collapse and nothing to do with air embolism. Dr. Bowen agrees with me. Well, by her own admission, she read my reports and conclusions and then coincidentally came to the same conclusions. Child M should not have been part of the criminal case, or indeed any criminal case, because the baby survived, recovered and was discharged well. It would never be part of a standalone case. Dr. Evans uses the term noxious substance in court to such an extent that it remains a headline article on the BBC website. This was not the actual allegation and was improperly introduced. It is, frankly, indefensible. The prosecution slings many weak, unrelated, and evidentially, at best, chronically poor arguments together, hoping some will stick, rather than having a coherent argument or case. A major part of this is attempting to relate child M to other infants, even though this is utterly erroneous. The paper towel raises its ugly head again. This should never be in a court case. It is utterly laughable. The skin discoloration described in child M is ordinary circulatory collapse-related discoloration, not the specific pattern associated with air embolism. Both the prosecution and medical experts patently misinterpreted this and misused research. The prosecution incorrectly treated all discoloration as evidence of air embolism, which is untenable and simply plain wrong. The probability reasoning is also overwhelmingly against the prosecution's case. If discoloration appears in only about 10% of air embolism cases, then seeing it in all alleged cases would be extraordinarily unlikely, to the point of being, to all intent and purposes, impossible. The real-world clinical course of child M is more consistent with apnea from sepsis. It is very hard to understand how this infant can be part of a court case. What becomes evident in the case of child M is the following. This was a crap neonatal unit with crap doctors who engaged in crap treatment, and then there was a crap investigation by Cheshire Police which engaged crap experts, and then there was crap evidence in a crap court case that very strongly points to a crap system. And I do always choose my words very carefully and try to be measured, but that was literally the most generous thing that I could find to say.